application and appeal in the matter of Kaitey and the Secretary of State for the Home Department.
Yes, Ms. Harris.
My Lords, I appear on behalf of the appellant, Mr. Kaitey, with my learned friend, Mr. Goodman, and the Secretary of State is represented by Mr. Tam, Queen's Counsel, and eminently Willesden, and you have, with the permission of the court, the benefit of an intervention by the bail from immigration detainees, and they are represented by Miss Laura Dubinsky and Mr. Anthony Vaughan, who unfortunately isn't present because he's isolating, but also with Miss Eleanor Mitchell. Those are the cast of today for YouTube and for the court. My Lords, if I can, before going to the substance of what is plainly an important appeal, just make sure that we're all working from the same documents. I apologise that this case wasn't dealt with when it should have been earlier this year because of my ill health.
No, there's no need for apologies.
I'm grateful, but just so that we make sure that we still are working from the same documents. Yes. I don't know if your Lordships have it in hard copy or are working exclusively from the soft copies and the electronic versions. I have old style paper.
Yes.
I hope that is going to mean that we're all working consistently. But your Lordship should have a core bundle.
Yes.
And a supplementary bundle.
Yes.
And I have it in 3 volumes of authorities. That
yes.
There may be some wrinkle with that because we may have put dividers in different yes. places.
Yes.
But I hope I can deal with that by going to the tabs and see where we go with that.
I think electronically it was divided into 6 volumes.
It was, yes.
And that's fine. We can cope.
We can cope with that. And I have it in 3 volumes now. I think you may have yours dividing at 35. In which case I'll accommodate that. Mine go up to 39, but I haven't amended it, but I think we'll be able to deal with that.
I'm sure we'll manage.
You should also obviously have, my Lords, in the core bundle.
Oh, I think we've got some recent authorities.
Yes, we do. That's correct. I was going to come to that.
Yeah.
The additional authorities that we served yesterday relate to cases, extradition cases.
Yes.
And go to the point, which was a point decided by the Court of Appeal in the B cases. Yes. Do you want to hand up the?
We already
have them already.
Yes,
I'm grateful.
I was slightly thrown because it says volume 7, but then I understood why.
That's why. Yes. So it's going to be our volume 4.
Yes.
It may be that this is the point is in issue. The point that that was successfully argued before the Court of Appeal and then endorsed in the Supreme Court is that in circumstances where a writ of habeas corpus is sought, the fact that the individual has been admitted to bail yes. does not end the court's jurisdiction. A critical important point we respectfully submit in this case, bail is not determinative of the lawfulness of detention, and it is not an adequate remedy, either under the common law, applying the ancient writ of habeas corpus, obviously now adapted to judicial review, as well as Article 5.4 of the Convention. So we already have authority plainly from the Supreme Court in B and the Court of Appeal in B. Yes. Mr. Tam seeks to go behind those authorities. We say the Court of Appeal on that point, where it was expressly referred to the old authorities, the Supreme Court were more concerned with the more recent authorities, which are to the same effect, is binding on this court.
Right.
But if the court wishes to see other categories of case where this approach is applied, we have provided the court with the extradition context. So if it's necessary to go to it where that approach is applied, bail will not mean that on an extradition, a challenge to an extradition case brought by way of habeas corpus, that the remedy has been isn't sought and isn't appropriately granted in those circumstances.
Yes.
But I bring them, and in fact I'm grateful to my own friend Mr. Dubinsky because she reminded me that those authorities had been before the Supreme Court in B, but was not necessary to go to them. But I thought if right. the court needs to see the full array from other jurisdictions, then you have those authorities. Right. And I hope that they're of assistance to the court.
Thank you.
So then turning to the legal arguments, you have 3 skeleton arguments which are in the
yes.
core bundle. And what you also have are 2 applications which go to ground 2 in this case. Lordships will have seen that in terms of the primary legal argument that we advance under ground 1, we say that where the statute now in Schedule 10 refers to liable to detain, that means liable to lawful detention, and means certainly means where detention would be compatible with the Singh principles, which are the implied limits of the broad statutory power to detain under the Immigration Acts. That's issue 1. But we also argued in the alternative below, issue 2, where there is a substantial measure of common ground, because Mr. Tam accepts, and has always accepted, that liable to detain does have within it the implied requirement that there is a lawful, that the power exists. So the Secretary of State's case rests upon a distinction between existence of the power and its lawful exercise. On the Secretary of State's case, one construes liable to detain to be limited to those categories of cases where there is a lawful power in existence. It can, and that is sufficient for the Secretary of State's interpretation. We go further and say when one is concerned with whether or not the power, there's a lawful power, it includes not just whether the power exists, but also whether it can be lawfully exercised.
Yes.
And it's in ground 2 that there is a dispute between the parties about whether that argument was properly advanced below, and we say it was, and I'll take your lordships to that shortly. Yeah. But in a related application that we filed on the 15th of October 2021, we have also provided the court with a decision of the First Tier Tribunal that has in fact dealt with this matter on the facts and made it plain beyond argument that this is a no power case on its facts, because the conclusion of the First Tier Tribunal being that the appellant is a Guinean national and there is no prospect of removing him to Guinea. The very late suggestion shortly before the hearing below by the Secretary of State that there's some possibility that this man is Ghanaian, having been rejected by the First Tier Tribunal. So those two applications go hand in hand, because if the court admits the judgment of the First Tier Tribunal, there is an appeal, but it's not against those facts. Those facts are binding as between the parties. The Secretary of State doesn't seek to go behind them. That, in fact, resolves this issue completely, and we respectfully submit in the appellant's favour on ground 2. That obviously leaves us to argue, and obviously for the reasons that the judge gave permission, that point of general importance should be argued. But we do respectfully submit that on the common ground, that liable to detain does not include those where there's no power to detain because there's no prospect of removal, then the position has been put beyond doubt on the facts of the case.
You put ground 2 as an alternative to ground 1, but if you're right on ground 2, ground 1 becomes irrelevant, doesn't it?
It becomes academic in this man's case. That certainly, we would accept that. But obviously, we would invite the court to determine ground 1, given the basis upon which the learned judge below granted permission, because it's a point of general importance. It affects potentially 90,000 people, maybe more now, who are subject to immigration bail. And so there's a powerful reason for this court to resolve that issue. And we invite the court to do so, even though we do submit that on the agreed alternative approach to the law, the facts have now been put beyond doubt.
Now, as you say, you've got 2 applications.
Yes.
Before this court.
Yes.
Subject to anything that counsel may wish to submit to us, our provisional view is that we should not resolve those procedural issues as a preliminary matter. We would like to hear all the submissions that counsel for all the parties would wish to make to us, including any objections that there may be, that in fact you do not have permission to argue ground 2 and that you should be refused permission to argue ground 2, and that you should be refused permission to adduce the new material.
Yes.
But rather than get stuck
down
in
into that.
the procedural issues at this stage or during the hearing, what we would prefer to do, subject to your submissions, is to hear you on everything, and then we will give our reasons for any decisions that we've made, including on those procedural issues, in our judgments in due course.
I'm most grateful for that indication, my lords.
I'm entirely happy with that course.
Thank you.
My lords, then, just to complete the terrain of the grounds of appeal, your lordships will have seen that in addition to the 2 grounds, one and the alternative 2, there is a third alternative submission, which would, in effect, place implied limits in the same way as the common law has implied limits into the power to detain, into the power to impose conditional bail, and so that it isn't open-ended and indefinite, but is subject to principles of reasonableness in the same way as the power to detain has been interpreted and its broad ambit restricted through a process of, we would respectfully submit, interpretation. That argument, we make that argument in our skeleton argument, but we will leave that argument to be developed by my learned friend Mr. Binsky, who developed it below. And so
Yes.
I will do it only by way of introduction.
Right.
And ground 4 then is in a way a part of grounds 1 and 2 because the court will have to grapple with what happens in circumstances where liable to detain no longer bites. So on our case, it bites in circumstances where there is no prospect of removal within a reasonable period of time, applying the Hardale-Singh principles, the Secretary of State, the Kadir approach, in circumstances where there's no prospect of removal. But on either category of case, the court would have to decide, construing this statutory scheme, what's the consequence of reaching that limit, wherever the limit is drawn. And in our respectful submission, in those circumstances, the only option under this statutory scheme is the grant of leave to enter or remain. The Secretary of State and the judge below thought that somewhat surprising. However, we respectfully submit that it's the only answer in circumstances where there is a comprehensive statutory provision in the Immigration Acts that provides for the circumstances in which people will be present in the United Kingdom. It does not provide for circumstances where an individual is simply at large. And the Secretary of State hasn't identified the power that she would be using to keep a person at large. On one analysis, it could only be a prerogative power if it's not something under the Acts. And so we say there's a very simple answer, that in circumstances where you have reached that limit, wherever the court decides it is, Hardale-Singh in short form, or Kadir, no prospect, we say that the only alternative at that point, as a matter of construction of the statute, is the grant of leave. Our alternative argument, based upon observations of, for example, Lady Hale in Kadir, is that it would be irrational not to exercise the discretion to grant leave. So we put it on that too, the 2 alternative bases. But it's obviously a separate ground, but it's very much related to the overall construction of the statute. And can I just say this before going into the substance of ground 1? The learned judge below decided not to address that issue because it didn't arise, having rejected the case, although only explicitly on ground 1. She also dealt with another aspect that's important in this case in relation to the incorrect interpretation and implication of the fact that individuals under this regime can be subject to conditions that are both an imprisonment and or a deprivation of liberty. So we'll look at the cases, but it's now established from a case called Jalla in the Supreme Court that a curfew, so requiring you to remain within your a premises designated space, constitutes an imprisonment at common law. And we know from other authority, again at high level, JJ, the control order cases, that a deprivation of liberty under Article 5(1)(f) of the ECHR can include conditions well short of actual imprisonment and have been found to constitute a deprivation of liberty if the curfew was over 16 hours. And I hope your lordships have noted from our skeleton argument that certainly in the context of the Special Immigration Appeals Commission, which equally applies this same statutory scheme, it has not been at all uncommon for the Special Immigration Appeals Commission to impose very strict conditions up to and including 24-hour house arrest for those who present a national security threat. Now, that context, and it's not in dispute between myself and my learned friend, the Secretary of State accepted below that the bail conditions provided for under Schedule 10 could constitute both an imprisonment and or a deprivation of liberty. The learned judge approached that aspect of the case on the basis that because it didn't arise on the facts, it didn't really need to be addressed in the context of the interpretation of the statutory scheme. And we do respectfully submit that this case does not turn on its individual facts insofar as we are advancing submissions about the correct construction of the statute as a whole. Because
can I be clear that you do not suggest that the conditions in this case amounted to either imprisonment of common law or a deprivation of liberty?
they do not, no. We fully accept that on his individual case, he has been on conditions that don't constitute an imprisonment or a deprivation of liberty.
I have to say, I find this a little curious. It may be my fault. Generally speaking, courts decide cases on the facts in front of them, and that's certainly the approach of the Strasbourg Court, which takes a highly fact-sensitive approach. I mean, we tend to shy away from deciding questions in the abstract.
Well, this is a question of statutory construction.
I understand that.
So in those circumstances, it's necessary to proceed upon the basis of the full class of case that will fall under this power. And that was certainly the position that was accepted by the Supreme Court in B. Mr. B was not subject, although he had very strict conditions, they did not come near to a deprivation of liberty. Nevertheless, that was obviously an important starting point for the court in its approach to statutory construction. The fact that, although this is about bail as opposed to detention in the first place, the fact that the bail conditions could constitute a deprivation of liberty, even though they didn't in the individual case, that was informed the court's approach to interpretation. And if I could just ask you, because I think it is important, I hope that the court will see, just to see how that was the approach in B. It's in tab 6 of the authorities. And the two relevant paragraphs are paragraph 29.
Yes.
And also in response to a submission that my learned friend Mr. Tam made about circumstances in which detention may become lawful. This is at paragraph 33. It's under letter E. Secretary, Mr. Tam, making the submission that the power of detention may sometimes revive, for example, because of a change of circumstances in the foreign state concerned, or because of a change in the risk which the individual presents. And the judge's observation, while that may well occur from time to time in individual cases, it is no answer to Ms. Harrison's objection, which is directed at the operation of the system of immigration bail. And so again, it may be that one can posit factual circumstances that mean that the argument wouldn't apply, or that the particular proposition wouldn't apply in the individual case. Similarly here, this is a case that is about the operation of the statute as a whole and the system. And so we do respectfully submit that you can't sidestep the significance of the fact that, one, this is a scheme that does provide for conditions that would otherwise constitute an imprisonment, would otherwise constitute a deprivation of liberty under Article 5.4, and where, particularly when one comes to look at the powers to re-detain, which we respectfully submit are at the heart of this case, although the judge below thought they cast no light on the correct construction. But this provision in paragraph 10, 10 to 12, provides for the power to re-detain or to detain for breach of bail.
I'm sorry to interrupt you. Sorry, had you finished that submission?
Yes, and I was just going to make this point about that. Again, the judge said, well, it doesn't have to be exercised. That was her answer to that primary submission that was made below by Mr. Goodman. But we respectfully submit...
What doesn't have to be exercised?
Sorry?
What doesn't have to be exercised?
The power to detain if the person breaches bail.
Oh, I see. I don't want to interrupt your flow at all, and I know you're going to come back to that.
I am going to come back to that, yes.
That's in the schedule, and it's paragraph 12.
That's right.
Yeah, I understand that, but I'm afraid, speaking for myself only, I'm still having difficulty in understanding the nature of the fundamental submission you're making about interpretation, because let's say on a set of facts,
yes.
Let's say a claimant has a perfectly viable argument that although they are on conditional bail,
yes.
they're being deprived of their liberty,
yes.
and or are being imprisoned at common law.
Yes.
Well, they could sue for false imprisonment.
Yes.
At common law, or they could bring a direct claim under Section 7 of the Human Rights Act and say, my convention right in Article 5 is being violated on these facts.
Yes.
And the fact that the Secretary of State has some power to impose conditional bail will be neither here nor there, because I don't think anyone could suggest that this power somehow overrides the fundamental rights in the Human Rights Act. And if necessary, Section 3 of the Human Rights Act would come into play.
Yes, of course.
So yeah. On the facts,
yes.
There would be a remedy which could be given by a court to vindicate both Article 5 rights and, if necessary, the tort of false imprisonment. So where does that get us in relation to how we construe this provision on facts which don't constitute a deprivation of liberty?
But for this reason, my lord, which is the principles of the core principles of statutory construction would mean that the court should, unless the clearest possible words have been provided by Parliament, construe this statute strictly and narrowly so that it doesn't have infringe upon fundamental rights.
Well, it can't do. Is anyone suggesting that this can't be interpreted compatibly if it had to be under Section 3?
Well,
because if they are, then we'd be into Section 4 territory.
Yes. Well, yeah, of course. If under the common law, those are the principles. Obviously, the interpretive obligations under Section 3 are, if anything, stronger to avoid a breach. So that if we are correct, and that it would, these powers do create a situation where there would be an imprisonment, a deprivation of liberty, and/or they would deny the right to an effective remedy, 5.4, then this court should construe it so that isn't what the statute does, and it should do that now in this case, not wait for some case where there is in fact a deprivation of liberty.
I'm afraid that's where I have the difficulty in the logic of the argument, because very early on in the history of the Human Rights Act, I think it was a case called Poplar Housing Authority, Lord Wolfe made it clear that you don't reach Section 3 of the Human Rights Act unless, on the facts, there will be an incompatibility with convention rights. In other words, you don't decide things in the abstract.
Well, this is not deciding it in the abstract, in the sense that we have here a statutory provision which, if construed in the way that the learned judge below did, and or construed in the way that my learned friend advances, does create situations of potential infringement of Article 5.1f and or Article 5.4 in cases where the person is not lawfully detained, and but the only remedy that can be provided for is bail.
It doesn't compel those situations. It's simply, if the power is exercised in one way, a situation may arise. If it's exercised in a different way, the situation doesn't arise.
But it's in my respectful submission, it's the duty of this court construing this statutory scheme to construe it in a manner, A, that is compatible with common law requirements of any provision that can infringe liberty should be strictly and narrowly construed, and you avoid a construction of the statute that would allow for that. Similarly with Article 5 of the Convention and Section 3 of the Human Rights Act. But perhaps the best way for me to pursue this argument is to do it in the context of looking at the statutory scheme.
Yes.
But I think it probably is important to have made that observation at this point, given the way in which the learned judge dealt with it below, and having showed you the way in which the Supreme Court addressed the matter in a case in which, although strict conditions, did not constitute a deprivation of liberty. My Lords, then, if I can turn to the point that in the argument, but perhaps before I do so, it's best to just look briefly at the facts. We can do that shortly because you will have seen from the judge's conclusion that the facts were not seriously an issue, and she has, we'll see from the judgment, which is in core bundle beginning at 113, set out those facts between paragraphs 4 and 13. And there is a very detailed cross-reference chronology, which I don't intend to take the court through. I hope that that's been of assistance. It's in the core bundle.
Yes, it has.
But what I would intend to do is just to add additional facts that are of importance, and I hope I don't need to turn up any documents except one or two when it comes to the position relating to some elements of the facts. But if you go to paragraph 4,
Yes.
that sets out the core facts of Mr. Kaitey, who I should have introduced at the outset, is sitting at the back of the court with two friends from the Gatwick Detainee Support Group.
Right.
And you'll see that it was accepted from the outset that the Secretary of State had delayed in investigating the issue of the ability to return this man to Guinea. But at the point of the judgment below, Mr. Kaitey had been in the United Kingdom for 13 years and having entered the UK on the 17th of December 2006. He made a claim for asylum, which was rejected, not on the basis of adverse credibility, but because he couldn't establish an ongoing objective risk. But that case was concluded, and he became appeal rights exhausted, which meant that from that point onwards he was potentially liable to removal. And that date, which isn't in the judge's judgment, but is the 28th of September 2007. So from that point on, the Secretary of State was in a position to remove. However, following, as you see from paragraph 6, following a conviction for the use of a false document, Mr. Kaitey was was sentenced to a 14-month term of imprisonment and subject to provisions under the 2007 automatic deportation provisions. He was also detained at that point, and the date of the detention is the 26th of August 2009. His appeal was dismissed.
Sorry, was that because he had a sentence to serve or because of immigration?
At the conclusion of the sentence, he was detained from the 26th of August 2009 under immigration powers.
Right.
Those would be the powers under Schedule 3 because he was now a deportation case. And that was the first period of detention. We'll see when it comes to an end, it was also the last, but he was actually detained on the 26th of August 2009. That appeal process concluded on the 8th of July 2010. And so it's been from that point onwards, again, that the Secretary of State was in a position to exercise the removal powers and to physically remove him from the United Kingdom. So now a period over 11 years ago. You will have seen from paragraphs 7, 9 and 10 of the judgment that the Secretary of State did take steps to seek to arrange the necessary paperwork and an emergency travel document for return to Guinea. 3 applications were made on the 4th of May 2007, the 26th of May 2010, and latterly and lastly on the 27th of May 2016. However, throughout that entire period, there was no positive response from the Guinean authorities, and throughout that period, the Secretary of State was unable to identify any timescale for removal, and then finally, the Guinean authorities responded in August 2016, rejecting the application for an emergency travel document. And if it's of assistance to the court, that document is in the supplementary bundle at 247. It's internal, what are called GCID records. It's the Home Office's own internal file. And they document the steps that were taken to seek to obtain this travel document. You'll see from 243 that there were no time scales, as I've indicated, and that goes on until we get to the refusal, which is at 247, about halfway down the page. Sorry, I think I've given you the wrong date. So you have to look at the dates below, and it's the 5th of September 2016. The embassy has refused an ETD because the subject is not Guinean. Name is Ghanaian. None of the information provided matches the school name is Ghanaian. So throughout that period of time, the Secretary of State was unable to identify a timetable for removal, a time frame. And then from that point on in 2016, no steps were taken to seek to facilitate removal to Ghana, to Guinea. And no steps were also taken to investigate the alternative of removal to Ghana either. I should just say, my lords, that the detention came to an end by way of a grant of bail on the 27th of January 2011. Yes.
Sorry to interrupt you, but that was a decision by the tribunal.
It was, yes, and your lordship will see that at paragraph 8 of the judgment below. Yes. We don't have all of those documents. If the court wanted to see them, we can. But he was granted bail subject to a number of conditions, which included a live and sleep requirement, electronic monitoring, weekly reporting, and also to appear before a chief immigration officer on the 3rd of March 2011. And from that point onwards, his bail was then, he surrendered to the immigration officer, and his bail was then issued by administratively, his restrictions on his leave. It wasn't bail. It was, yes. Sorry, he was put on restricted leave by the immigration officer, so it transferred over, which is the standard practice that occurs.
Presumably because necessarily we're talking about a time before the 2016 Act came into force. The original grant of bail and the original imposition of conditions in 2011
Yes.
were all done under an earlier statute.
They were. They were all done under the
Do
provisions
we
of the
need
1971 Act.
the 1971 Act, presumably as amended, do we need to know what precisely the legislation was under which he was the subject of conditional bail?
I was going to take you to those provisions so that
All
you
right.
can see the contrast, but if you'd like to do it now while you have that in your mind, I was going to show you those briefly
you
because
do it in
the
the order
contrast
you
was,
think
was
best.
there. We're going to come to that shortly. Yeah, so from the point at which the 3rd of March 2011, it has been under the auspices of the immigration authorities rather than the court.
As I understand it, the FTT made its decision on the 21st of January 2011.
Yes.
He was physically released from detention, as I understand it, on the 27th of January. That's what I've seen in the papers. It may not matter precisely what date it is, but anyway, what then happens as a matter of practice? Did the FTT itself impose conditions, or did it leave that to the Home Office?
No, the FTT did impose conditions.
Yes.
Those conditions were to live and sleep at an address, a tag, electronic monitoring, weekly reporting, and to appear before a chief immigration officer on the 3rd of March 2011. The tag was in fact removed on the 5th of July 2011.
Thank you.
And I'm sorry, you said that when he appeared before the chief immigration officer, those restrictions transferred across.
Yes, they do. So he surrenders his bail.
He surrenders to bail. And
That's right.
And does the chief immigration officer then re-grant bail subject to the same conditions?
Let me just double check. I'm sorry, we should have provided you with these documents. He was placed on a restriction order. So he wasn't bail, it was a restriction, which is under the schedule. It's the alternative to detention in deportation cases.
Under the 1971 Act.
Under the 1971 Act.
So it's a restriction order.
It's 2.5 of Schedule 3 of the 1971
Well,
Act.
can we just take this a bit more slowly? If you
Sorry,
don't mind?
yes.
So, give us the provisions again.
It's Schedule 3,
Yeah.
paragraph 2.5 of the 1971 Act.
Right. So is this right? So for a couple of months, he's subject to conditional bail granted by the tribunal.
Yes.
But then, from the 3rd of March 2011, he's not subject to bail. He's subject to a restriction order.
Yes.
And how long did that last? Until 2016?
That was until the until the implementation of the 2016
Right.
Act, and we have that document in the core bundle, which is at 242. So
Core bundle or supplementary bundle?
it's in the core bundle. It's the last document in the core bundle.
Right. Thank you.
So when the judge says in paragraph 8, he has been on bail since 2011, that's not actually strictly true.
That's not correct. No, he was on restrictions.
Right. Now, is it your case, therefore, that although he was subject to a restriction order by the executive and not bail, under previous legislation, that something fundamentally different was introduced
Yes.
in the 2016 Act?
Yes.
Which is called bail?
Yes, it is, because, and the fundamental difference is that under the restriction provisions in the schedule, he couldn't be re-detained for breach of those conditions. He could have been prosecuted for a breach of them, but
He
he
could.
didn't face. Yes, he could have.
Yeah.
There's a provision in Section 24 of the 1971 Act for prosecution, but breach of them wouldn't result in a power of immediate arrest and possibility of being re-detained. And the only conditions that could have been imposed upon him under the restriction regime related to residence, employment, study, reporting. And when he is now subject to bail, there are very much wider powers that could be imposed, critically powers that could constitute an imprisonment, which weren't permissible under the regime in place then. We know that from the case of Jala. So you cannot impose a curfew. So you cannot require the person to remain within their premises for a specified period, because that's an imprisonment. And that's the Jala case at tab 48, which I'll take you to.
I do understand that.
I'm grateful. And obviously it didn't allow the very much broader powers that there are. So, for example, you could put restrictions on communications, on contact with other people. There's a huge panoply of powers that arise in circumstances where the conditions are predicated on the fact that you could in fact be detained, and therefore the statute would have allowed for much greater intrusion into liberty, including deprivation of liberty. So that was how that system operated.
I do understand, and I know that you're going to come back to this. You'll help us in due course with that. That's all fine. I understand that there can be extreme situations where on the facts there may be a deprivation of liberty. But what I'm interested in at the moment is where you have what might be called, not an extreme case, but this kind of case, where everyone was proceeding on the basis that he should be subject to a restriction order with various conditions. Was it possible after the 2016 Act, as a matter of law, to continue a person on that kind of regime?
No, because that wasn't possible, because that power was repealed.
Quite. So one of the things that we may have to decide in this appeal is what was the intention of Parliament
Yes,
in repealing that earlier regime.
yes.
And your submission is it that Parliament didn't cater for that kind of limited regime any longer to be imposed?
Yeah, what Parliament did was to repeal the provisions that allowed for release on restriction, whether it's temporary admission,
Yes.
if or in cases of deportation, restrictions.
Yeah. I don't want to take you out of turn at all, and I do mean that. But at some point, certainly speaking for myself, I would be assisted by any submissions you can help us with as to what the policy behind such it sounds like a very radical change
Yes.
in the law of this country in relation to immigration. And usually, Parliament doesn't effect radical changes, or perhaps any change, without there being quite a long sort of run-up to that. Sometimes there's a law commission proposal, sometimes there's a white paper. One sees that there is a development of policy which culminates in a fundamental legislative change happening.
Yes.
But on your submission, was there any reason for Parliament to repeal the earlier quite limited regime and no longer allow the Secretary of State to be able to do what he or she had been doing until then?
Well, the history obviously indicates clearly that it was in response to the Court of Appeal judgment in B. So the Court of Appeal had concluded that there was no lawful power to impose bail in circumstances where the person could not be lawfully detained. And the that's what the Secretary of State relies upon as the explanation for the introduction of Section 61 of the 2016 Act.
I know, but on your submission,
Yes.
given the construction that you
Yes.
advocate this court should give to the 2016 Act, what sensible policy purpose lay behind Parliament's decision to repeal the provisions which had allowed the restriction order, kind of what I've called a relatively limited regime,
Yes.
to get rid of that completely, no longer allow the Secretary of State to impose those sorts of conditions, and then, well, presumably on your submission, you say that you can't even impose conditional bail for all the reasons that you're going to develop under Ground 1.
Yes.
What's the policy thinking which leads to that outcome?
Well, the two answers to that, first of all, is that obviously when it comes to statutory construction, we're looking at the objective language that Parliament used. So what is the meaning of the words that they used, which isn't normally defined by reference to the subjective purpose of Parliament. So that would be my answer in principle. But my second answer, which is obviously the one that you're going to be more interested in, is that plainly, once the Court of Appeal had ruled that you could not impose bail in circumstances where there was no lawful power to detain, there was then a substantial category of cases that could be affected by it. When the words that they use can no longer be detained, which is the language that is in Section 61, which was subsequently repealed but finds its way into Section 1.5 of the Act, is to deal with cases where detention was not justified, which is the large number of category of case. So you have a small category of case where people are detained in the overall scheme of things. We know that in any 1 year, at any one time, there's only 3,000 people who used to be at that time in detention. So those who are detained is a very small number of those who are subject to immigration control. Within those who, and obviously within those who are detained, there's an even smaller category of persons who are unlawfully detained. So that deals with that. But what were the implications or the potential implications of the judgment of the Court of Appeal is that you had a whole category of people who had never been detained and detention was never justified. There may have always been a lawful power, but it was never exercised because it wasn't necessary. So because there wasn't a concern that they would abscond or commit offences. So the vast majority of people were released on temporary admission. And obviously those who faced deportation who didn't need to be detained. They were probably going to be in a much smaller category, but were on restricted leave. So in my respectful submission, what one can see is that Parliament had to address what could have been the potential very wide ramifications of the Court of Appeal's judgment about the category of case, which is the vast majority of cases, where it could have been argued that if you had never exercised the power to detain this person, it was never necessary, they could have fallen within the rubric of the Court of Appeal's judgment. And it's that makes it clear why Parliament chose the language of Section 61.3 and 1.5 can no longer be detained. Would have been the easiest thing in the world for Parliament to have said can no longer lawfully be detained. But that's not what Parliament chose to do. It chose to address, in my respectful submission, the very much bigger category of case, which is those who have never been, who could not be detained because there was never any proper basis to do so. And that's the largest category of case, many thousands of people. And so my understanding of what Parliament sought to do was to address the very wide ramifications of the implications of that judgment, and it did it on an urgent basis. Obviously, that was then subsequently repealed, and we have the Schedule 10, which is the key provisions that we have to construe here. Mm-hmm. But there is a sensible way in which one can understand Section 61 and Schedule 10.1.5 of the 2016 Act, which is Parliament was concerned to ensure that all those who the Secretary of State had never thought to detain, lawfully or it was never justified, were not going to be caught by the implications of the judgment. Obviously, the judgment itself was concerned with a case relating to Singh principles, but it was not limited to that, and certainly in the Supreme Court, it was made clear that it went wider than that. So that's my understanding of what Parliament intended to do. It's also clear that Parliament intended to, what they say in the explanatory notes, is to simplify the system so that you only have limited categories. You don't have temporary admission, restrictions, bail, leave and detention. You narrow down the options to detention, bail, and we would respectfully submit leave to remain or enter. The Secretary of State must say some category of person where there's no prospect of removal. Kaitey case must be at large because there's no other category open to the Secretary of State to exercise. But so it was a simplification also. So you didn't have people on different kinds of leave. And
Do we have the explanatory notes?
yes, we do. Would you like to look at those?
Just give me the reference.
Sorry, Lord.
Tab 81.
I'm grateful. Tab 81.
Thank you very much.
I can give you the relevant references if you'd like to have those now, or if you want me to take them to it. I'm happy to do that.
That's fine.
You're happy with just the tab?
Happy with the tab reference.
I'm grateful. Thank you.
Can I ask you?
Can I just make this one?
Yes,
Sorry, just the final follow-up point is that the learned judge below and the Secretary of State say, well, in repealing temporary admission, the Parliament intended to replace that with bail. But in my respectful submission, it can be looked the other way, so that Parliament created circumstances in which it was delineating those who could be put on leave, on conditional leave, and was limiting it to the category of case where there was a lawful power to detain.
Is that to reverse Kaitey by legislation? Because as I understand
It doesn't reverse Kaitey in the sense that Kaitey is concerned with temporary admission.
Exactly. Let's just confine ourselves
Yes.
to the concept of temporary admission. As you say, Parliament abolished the concept of temporary admission in
Yes.
2016.
Yes.
So does it follow from your submission that Parliament intended to reverse the effect of Kaitey? Because Kaitey had held that you could have temporary admission
Yes.
where somebody's liable to detention, but in fact could not lawfully be detained.
Yes, on the narrow basis that there was no power. And so we respectfully submit that what Parliament did in 2010, in the 2016 Act, is to apply the B approach. So it got rid of temporary admission, which was limited, which could be exercised, could be imposed in circumstances where there was the possibility of lawfully exercising detention, but the power didn't exist. Instead, the Parliament chose bail, and it chose bail knowing that bail cannot be imposed on persons who cannot be lawfully detained. And that is obviously established by the judgment of the Supreme Court in B, but it was well established way before that in lots of other authority. And in fact, the Secretary of State herself had advanced precisely that proposition in the Strasbourg court in a case called Ismail. So Parliament didn't need B to tell them that bail is only imposed in circumstances where there's an underlying lawful power to detain, because that was well established in the common law. Perhaps going back for centuries. We don't need to go back for centuries because the authorities that were referred to in B are clear, and I can take your lordships to them. But
it does sound, forgive me, it does sound from your submission, and it may be right, it does sound as if Parliament intended to introduce quite a serious narrowing of the powers of the Secretary of State. That where we know that before 2016, the Secretary of State could grant temporary admission,
yes,
as per Kadir. We know, as on the facts of this case, the Secretary of State could grant or impose a restriction order.
yes,
But you say in 2016 there was a quite deliberate policy decision taken by Parliament. Secretary of State, you are no longer to be able to do those things. Your powers are going to be confined to what follows from the legal concept of bail.
yes.
And that may be right, but do you accept that that's actually quite a considerable narrowing of the powers which the law had previously given to the Secretary of State?
Well, it's an extension of the Secretary of State's powers, in that there was a whole category of person who had temporary admission who could only be subject to very limited conditions. Following the 2016 Act, all of those people then were subject to immigration bail and were then subject to the potential for very much more onerous, intrusive measures. So in that sense, it was an extension of the Secretary of State's powers.
Yes.
And there's no category of case that was covered by temporary admission that can't be covered by bail, save for, we respectfully submit, the category of case where the person can't be lawfully detained. So it allows for those to be on bail where detention's not justified, it's not necessary, because you can impose conditions and the person will be able to be traced or be able to be located and will turn up and can be removed if their case is lost. So they are all covered by this provision, which was the vast majority of temporary admission cases. And there's no objection to that, subject, of course, to what conditions are imposed and them not being disproportionate, obviously. But that category of case is covered by bail. But what we respectfully submit is that it's the same position as far as those who cannot be lawfully detained. And we say that that's not confined to the narrow category of Kadir, i.e. where there's no power in existence. It extends to those where there is the power can't be exercised, yes, in accordance with the Singh principles.
Right. Well,
and can I just make this one final observation about the options?
Yes.
It does also mean that Parliament would be cognizant of its powers to impose limited leave and its policies that it's adopted with respect to limited leave, which the court may be aware have been developed over a number of years to impose. This is in the limited leave powers in schedule. It is in Section 3 of the 71 Act.
Yes.
Very temporary rolling leave for 6 months. And it can include, for those categories of case where, for example, national security or other public interest cases, what's called restricted leave, which allows for much greater intrusive conditions. So Parliament would have been aware that that there had developed over time very much more tailored forms of leave to deal with those people who it may not be possible to currently remove them. There's an intention to do so, and you keep that constantly under review. So that's the 6 months rolling discretionary leave or restricted leave. And so that was the policy context for this provision. And perhaps the only other observation to make is that what Parliament would also have been aware of is that in 2014 and 2016, it created the hostile environment for those who are here illegally and should leave. So there had been a change in circumstances, and it's referred to in some of the authorities. The court may be familiar with what the hostile environment provisions were, but they included being excluded from certain provisions of healthcare, not having any recourse to public funds, not being able to attain private rented accommodation, not being able to work, not being able to have a driving license. So a whole system of measures that were introduced to do what the Home Secretary announced at the time, to create a hostile environment. So that was also the context in which this legislation was introduced. And so if you're in a category of case where you cannot be removed, you simply cannot be removed, you've got to that point, either at all or within a reasonable period of time, then those would be a category of case where the hostile environment provisions would not be appropriately imposed. That's another factor that could have played in the mind of Parliament about the choices that were made. My learned friend says, well, it's simply just to remedy and to reverse retrospectively the judgment of the Court of Appeal, although that would have obviously, we respectfully submit, been unlawful in Mr. B's case. But we say there's a much wider picture here that Parliament was considering. Right. And if you look at it in that context, we respectfully submit that our analysis of the words used, which ultimately is the key issue here, what are the words that were used, what's their meaning, as opposed to what was Parliament's purpose or policy aim, you've got to look at what the language did, and we'll come to look at that. So I'm sorry that that's slightly moved away from the facts, but I think it is important just to have a look at the document, which is, following it through, the document that did transfer my client from restricted conditions to bail under the 2010 Act, and that document is at 242 of the core bundle.
Yes.
So it was dated the 5th of June 2018. And you'll see that the box that was ticked in respect of the appellant is H.
Yes.
And you'll see that it's significant that he says you are liable to be detained for the following reason. You are subject to a deportation order.
And that was accurate.
Well, it was accurate. However, what's important to note about that is that unlike any of the other categories, A to G, it's not related in any way to the powers of removal. It's simply that you are subject to a deportation order, and it is an important part of this scheme that it is disconnected to the exercise of immigration powers, which has always been a qualifying aspect of the Secretary of State's what can obviously be intrusive, draconian immigration powers. They've always been in play for the purpose of effecting removal and conditioned by removal and the time in which that would take place. But this particular basis for imposition of bail was simply that he was subject to a deportation order. Obviously couldn't be, we respectfully submit, asserted that he was going to be removed within any identifiable period of time, even in 2018. You will also see that he was then subject to conditions. So the bail is as one would expect when one is using bail. It's conditional on those factors that are set out below. Just so that you're aware, in terms of the SOL list, which is the provisions for work, that's a very, very narrow category of work that the vast majority of people can't ever qualify. They're highly specialist doctors or ballerinas. It's a very limited category of person that's on the list for those who you can work with, and the vast majority of people are not able to work, even though in principle there's a possibility. And that's certainly been the case for this man for this entire period of time.
But even if it had said you are allowed to work in other occupations, your fundamental submission would still have been the same, wouldn't it? That as a matter of statutory construction, there's no power to grant bail.
For this man, in circumstances where he couldn't be lawfully detained, the conditional bail couldn't be imposed upon him. Yes, that is my submission. And one of the reasons, and a critical reason, is because if you go on to 244, you'll see what's said about the failure to comply with conditions. So failure to comply may lead to arrest. Your conditions being varied, the requirement to pay money under any financial condition, and all of that is there, but then it also says, and or your detention.
Yes.
It makes clear that it's a criminal offence, but it also preserves for the Secretary of State the power to detain. And we respectfully submit that that power cannot be exercised, even if he did breach his bail, in circumstances where he couldn't be lawfully detained, because to do so would breach the Hardell-Singh principles.
Yes.
And you'll see there that it does come to an end in circumstances where you're no longer liable to be detained, and the Secretary of State is not considering whether to make a deportation order against you, granted leave, you are detained, or you are otherwise removed. And so you are no longer liable to be detained. On the Secretary of State case, that is as long as there is some prospect of removal and an intention to do so. On our case, it would be in circumstances where the power to detain could be exercised compatibly with Hardell-Singh principles. So on the Secretary of State's case, it is essentially a prolonged period of time without any real temporal limit and no implied restrictions whatsoever, so long as there's some prospect of removal. So I hope that
Before we leave the facts,
yes.
can I ask you, that document, which as you say was dated 5th of June 2018, says that it's a variation of bail, not the grant of bail.
Yes.
So when was the 2016, when did the 2016 Act come in and repeal the provisions for restriction orders, which was the then regime? And what then happened? Do you automatically transfer to bail under the Act, or does the Secretary of State issue everybody with a grant of bail who was subject to a restriction order?
The Schedule 10 came into force on the 1st of January 2018. So I have this, as I understand it, was the first time that the bail was imposed. It isn't a variation; it is the imposition of bail for the first time.
What was his status between the 1st of January 18 and the...
That I'm going to have to ask the Secretary of State to explain that, because there appears to be, on the facts, I'll double check this, a delay before it was that there was a transfer into the 2016 regime. And that may be an oversight by the Secretary of State, but couldn't have been on the restriction, so in theory he would have been at large during that period of time.
It'd be very surprising if there were no transitional provisions, that everybody switched overnight when it would be impracticable to impose bail conditions overnight on everybody.
I'll double check that. I hadn't, Mr. Tam may be able to assist. on the documentation that I have seen, this is the first notice that imposes bail.
Even though it's described as a variation.
Yes, I think that notice is wrong.
So, are you able to say, and maybe you're not, whether the conditions which we see on page 243 are similar to the conditions which he was subject to when he was subject to a restriction order?
I can double check that. They are similar, certainly. So is it really? Okay, so that's oh, sorry. Yes, sorry. It's getting confused. I can just double check now. Yeah, though I think it looks like those are the same conditions.
Thank you.
The primary difference is that he couldn't be detained for breach. Now, because it's bail, he can, whereas that wasn't possible under the restriction order. It's simply prosecution. That's the main practical change for the individual.
And can you tell me this? If you look at page 250 of the supplemental bundle,
250 of the supplementary bundle.
Yes, in the case record sheet.
Oh, yes.
You'll see an entry in the middle of the page, CMWT reporting compliance check, SOS immigration bail. And a bit further down, 3 consecutive breaches required before bail 204 issued, no further action taken on this occasion. And I think you told us the date is the one that appears below it, rather than...
I think that's right, yes.
So, 21st of April. Do you know what a bail 204 is? It's obviously a form of some sort.
I don't know what that is. No, I'd have to check probably with my instructing solicitor.
I mean, that would suggest that in the minds of whoever wrote this, he was on immigration bail in April, whereas I think your submission was that between January and June, he was not actually on any restriction at all.
Well, can I just say this? The documents that I have, document that I have that was issued to him that put him on bail under the 2016 Act, the first document that I have seen is June.
It's June.
So it may be that there's a document deficit on our part. That we can clarify. I don't think it makes... yes, there may have been a hiatus, a period of time when that came into force, but for our... I don't think it makes any difference to our purposes. But what I suppose it does illustrate is clearly the point that I made about the policy implications. The Secretary of State had a very big task to deal with once it had decided to transfer, as it were, the large number of people on temporary admission and or restrictions onto bail.
But that points up my Lord's point. What one would expect Parliament to do if it was abolishing temporary leave, on which you say the vast majority of people who never needed to be detained were, on the 1st of January, that they would automatically transfer onto some sort of new system rather than just be left in limbo until the paperwork could be completed.
Yes, it may be that the statute had that immediate effect. I haven't looked at it from that point of view. I've looked at it from the purposes of the documents. What is apparent and is obviously common ground is that he was at some point, whether before or certainly by June, he was transferred onto immigration bail under Schedule 10.
Yes, but it may be relevant, again to pick up my Lord Justice Singh's point, when trying to ascertain Parliament's intention
Yes.
as to whether Parliament did provide that people who were on temporary leave would automatically transfer with similar conditions to bail, or whether that was
Temporary admission.
temporary admission, whether that was something that had to be looked at afresh in every case.
Well, that is a matter of perhaps a fact that I don't know what the Secretary of State did in individual cases. But certainly there would have been a category of case, for example, where if you were on a restricted leave, on a restriction order, you couldn't have been subject to a curfew, for example, because of JALO. So there is a category of case, and there may be, a learned friend, Mr. Binsky of BID may have a better idea about this, but there could certainly have been a category of case who, after the implementation of Schedule 10, the Secretary of State was able to put those people on curfew conditions in circumstances where they'd had to withdraw them because of the litigation in JALA. And my learned friend, Mr. Tam, may be better able to assist that, but there certainly was a significant number of people who were in that category, and it would have been permissible to do so in principle under bail, but obviously not under temporary admission or restricted
Thank you.
leave.
Right.
Right,
Where
so
do we go from there?
what I'm going to ask the court to do now is to look at the statutory scheme. We set it out in our skeleton at page 24 to 31, paragraphs 15 to 44. And again, you will have seen helpfully in the judgment below, the learned judge set out in chronological form the history of the developments in the statute. So it may be of assistance to keep that open. But what I'm going to show you first is the provisions that were in place prior to the implementation of the changes in 2016. And you find those in tab 11 of the First Authorities bundle. So I hope that the first document that you have is Schedule 2 to the 1971 Act and Para 16, which is the power to detain pending examination and pending removal.
We have paragraph 21.
I think we had paragraph 16 sent separately.
Yes, we did. Sorry, I didn't. I'm grateful. Yes, I hoped it got
Just
into
very
you.
recently.
Yes, I'm grateful.
It was at the back of the supplementary bundle that we were sent.
Right.
Certainly in my case.
Yes.
Just loose.
I do have it elsewhere. It may be that it's no, I don't.
I think it's got a tab 11 at the back of the supplementary bundle.
No, I'm afraid I haven't received that.
I say supplementary
Sorry.
bundle, additional bundle.
Yeah,
authority, so.
yeah, no, I didn't get that. Do you want to hand that up?
I can have it as a copy. Sorry.
Yeah, I'll just insert it here.
I have two. If that's.
You do have it.
I've found it.
You found it.
Thank you very much. Just wanted to.
No, I didn't have it in that one.
For Lord Justice Singh.
Yeah, I think I'm the only one who's missing it, but
Sorry.
I've got it now.
Yes, it's the first. It should be the first document in tab 11. Sorry that didn't.
Thank you very much.
Wasn't the instructions weren't clear.
Okay, thanks. Right.
It may be familiar to some of you in the court, but
Yes.
it's 16.1 provides for the power to require a person to submit to examination and that they may be detained. And it's important just to note for the reference under the authority of an immigration officer, because that phrase "under the authority" is used subsequently, and is of significance. And secondly, the other power is in 16.2. If there are reasonable grounds for suspecting that a person is someone in respect of whom directions may be given, that person may be detained under the authority of an immigration officer pending a decision whether or not to give such directions, his removal in pursuance of those directions. So that's the power to detain that's exercised most frequently. And you'll be aware that the alternative to that is in Schedule 2, Para 21, was temporary admission. And you'll see that at 212. So a person liable to detention or detained under paragraph, etc., above may, under the written authority of an immigration officer, be temporarily admitted to the United Kingdom without being detained or be released from detention, but this shall not prejudice a later exercise of the power to detain. And you'll see in 21.2 the extent of the conditions that could be imposed on temporary admission. So it's such restrictions as to residence, as to his employment or occupation, and as to reporting to the police or an immigration officer, as may from time to time be notified to him in writing by an immigration officer.
So is that what applied to Mr. Kaitey?
No, this applies to people who are not subject to deportation. So we'll look at those powers next. And then we'll come back to bail, so we can do that in one go. So then the power to detain for those who are liable to deportation are in Schedule 3, Para 2, and you'll find those at 221. And you'll see that there are 3 circumstances in which one can detain someone liable to deportation: if there's been a recommendation for deportation by a court, and he can be detained pending the making of a deportation order in pursuance of a recommendation, unless the Secretary of State directs him to be released pending further consideration of his case, or he is released on bail. And the alternative power is in 2, where notice has been given to a person in accordance with the regulations of a decision to make a deportation order against him. He may be detained under the authority of the Secretary of State pending the making of a deportation order. And finally, in 3, where a deportation order is in force against a person, he may be detained under the authority of the Secretary of State pending his removal or departure from the United Kingdom, or if he's already detained by virtue of subparagraph 1 or 2 above, when the order is made, shall continue to be detained unless he is released on bail or the Secretary of State directs otherwise. And we see what the otherwise is in paragraph 2.5 on 222. A person to whom this subparagraph applies shall be subject to such restrictions as to residence, as to his employment or occupation, and as to reporting to the police, as may from time to time be notified to him in writing by the Secretary of State. The persons to whom subparagraph 5 apply are a person liable to be detained under subparagraph 1, while by virtue of a direction of the Secretary of State he is not so detained. A person liable to detention under subparagraph 2.3, while he is not so detained.
Yes.
And so in those circumstances, limited restrictions on freedom and liberty were permissible.
Well, you say limited, but some restrictions were possible.
Yes, they were.
Where you were a person liable to be detained, as construed, would you accept, by the House of Lords in Kadir?
Yes, for release. Yes, yes, we accept that. That Parliament made a distinction between detention, where the remedy was bail, and in circumstances where it was restrictions, it was only where the person was liable to be detained. I fully accept that. And
liable to be detained in the sense used by the House of Lords in Kadir. In other words,
yes,
where it was not possible lawfully to detain them.
Yes.
Yeah. So
yes.
Your submission, your fundamental, because I know there's lots of detail, which is important.
Yes.
But your fundamental submission, I think, is that in 2016, Parliament effected a very important shift in the law, which was that however large or small the category of persons may be, there is undoubtedly a category of persons of whom Mr. Kaitey may be an example, where before 2016, the Secretary of State could lawfully put them under this kind of regime, as per Kadir.
Yes.
And after 2016, you say, can't do that. That's why we're here.
Yes.
Your whole case is that
yes.
you can't do this to Mr. Kaitey.
Yes,
so
you can't, because because you
that's
could have put him under temporary admission. You could have put, yes, you could put him under temporary admission, But what you couldn't do is, and what
Well,
we
no,
say
not,
you
not
can't do
temporary
is subject
admission.
him to bail.
Sorry, not temporary admission, precisely because of the point you made that this is a deportation case. So what we're dealing with is this paragraph here that you've just been showing us. Is that
Yes,
right?
but it's the equivalent of temporary admission for those who are not liable to deportation.
And I understand that.
Yeah.
But your fundamental submission of statutory construction
Yes,
to
yes.
us is that we should construe the 2016 Act as not allowing the Secretary of State to do something which previously she did have power to do. In this category of persons.
Yes, because
Yes.
because he can't be lawfully detained.
Exactly.
Yes. Yes.
Can I just
So she could have. Our position is that this is what she could do,
Yes.
and what is what her powers now are limited to.
Can I?
But it's not under temporary admission because it's been abolished. It has to be under limited leave to remain.
Limited leave to remain.
Yes.
So they have to be given leave, whereas previously
You had a temporary status.
we know that it was a carefully constructed statutory regime, that temporary admission was precisely not leave.
Yes,
That was the whole
that's
point.
right.
Yeah.
It was authorization to enter, but it wasn't leave.
Yeah, so you say that Parliament has effected what some might regard as quite a fundamental change in immigration law.
Whichever way one looks at it, this is a fundamental change in immigration law,
Yes.
because it fundamentally subjects individuals who previously couldn't be subject to onerous conditions because they couldn't be lawfully detained to the potential for onerous conditions.
I see.
And also makes them liable to be re-detained if they breach it.
Yes.
Before you leave this, can I be sure that I've understood which subparagraphs applied to Mr. Kaitey before this Act was repealed?
It was
It's-
2-3.
We're looking at Schedule 3, not Schedule 2.
Yes, that's right.
So we're not looking at temporary admission under Schedule 2 at all.
No, not
We're
for
looking
him.
at Schedule 3. And at Schedule 3, Paragraph 2, Subparagraph 3, because there was a deportation order in force against him, is that right?
Exactly. Yes, your lordship
Yes.
has it right.
And under that, Parliament has said he shall continue to be detained unless, and then there's two options. One is released on bail, which seems to have been added in 2003,
Yes, before that there was no power.
or the Secretary of State directs otherwise. Now, which was it? Was he released on bail, or
It
was
was directs
he? It was
otherwise.
directs otherwise.
And then under 2-5.
And under 2.5, because he is a person under 2.6b, a person liable to be detained under subpara 3 but not so detained,
Yes.
therefore subpara 5 applies to him and he can be subject to restrictions.
Yes.
And that's what you call a restriction order.
Yes,
Although it's not a statutory term in this.
Released on restrictions.
He's
Restrictions.
released. He's a person to whom the Secretary of State has directed otherwise under subpara 3, but subject to restrictions under subpara 5.
Yes. So it
Yes.
is.
Okay, my question is this: we know, as my lord has said, that in accordance with the House of Lords' decision in Kadir, that regime could apply to him,
Yes.
even if he could no longer lawfully be detained, as long as the power to detain existed, even if
Correct.
it couldn't be exercised.
Correct.
Now, my question is this: could he, under the power in subparagraph 2.3, have been released on bail?
No, he couldn't. Not applying the judgment of the Supreme Court in B, he couldn't have been because there was, and it's common ground, there was no prospect of removal within a reasonable period of time. You couldn't satisfy the Hardell-Singh principles. So he couldn't have been, no.
Thank you.
Just so that you see that in paragraph Schedule 324A, that the provisions relating to bail apply to deportation cases, and those provisions as to bail are in paragraph 22 to 24 at 214. So the powers to release on bail covered both deportation and non-deportation cases. And you'll see at 1A, it could be released by a chief immigration officer or by the First Tier Tribunal. It provided for the imposition of recognizance and bail bonds, and fixing conditions of bail at 3. So that was the bail power, and 24 was the power to arrest if without a warrant. This is at 218. Those who were released by virtue of paragraph 22 in circumstances in which there are reasonable grounds to believe that the person is likely to breach the conditions of his recognizance or bail, and he would be required to appear at a time or a place, or to break any other condition of it, or has reasonable grounds to suspect the person is breaking or has broken it. So that was the power of arrest for breach, and you'll see at 224(2) that he had to be brought before an immigration officer within 24 hours after the time of the arrest, as soon as reasonably practical, be brought before the First Tier Tribunal, or if that is not practicable within those 24 hours, before a justice of the peace. And then the powers of the First Tier Tribunal or the justice were to, if he has broken or is likely to break any condition on which he was released, may either direct that he be detained under the authority of the person who he was arrested, or release him on the original recognizance or on a new recognizance, with or without sureties. So the two options were to detain under the authority of the person by whom he was arrested, or to release. So those were the powers that were construed by the Court of Appeal and the Supreme Court in B. And if we just go to the B judgment, I'm sure you've had an opportunity to read it, but if we can just look at the key paragraphs in the judgment of Lord Lloyd Jones, who gave the judgment of the court, and you'll see in the discussion, which begins at page 78, paragraph 26, in that case, it was accepted, as we respectfully submit, is in this case that that Mr. B couldn't be subject to administrative detention in accordance with the Hardell-Singh principles. Mr. Tam advanced a purposive interpretation of those provisions, which would have allowed bail to be imposed, even though Mr. B couldn't have been lawfully detained. And that was rejected by the Supreme Court, paragraph 29, no basis for adopting the purposive approach for which the Secretary of State contends, resting as it does on a disregard of the issue of the lawfulness of any continuing detention. It's a fundamental principle of the common law that in enacting legislation, Parliament is presumed not to intend to interfere with liberty of the subject without making such an intention clear, by reference there to the Tam T. Lam case, Khawaja, and quoting from Lord Justice Laws in the case of Mahmood. While, of course, Parliament is entitled to confer powers of administrative detention without trial, the courts will see to it that where such a power is conferred, that the statute that confers it will be strictly and narrowly construed, and its operation effect will be supervised by the court according to the highest standards. In the present case, our particular focus is not on a power of the executive detention, but on the power to grant bail. Nevertheless, and despite the fact that the purpose may be to effect a release from detention, I consider that this similarly attracts the presumption of statutory interpretation, because the conditions which may be attached to a grant of bail are capable of severely curtailing the liberty of the person concerned. It was common ground before us that bail under the 71 Act may subject to conditions which constitute a deprivation of liberty. As Mr. Tam frankly accepts, the ability to exercise control through the use of what may be stringent conditions of bail in part underlines the purposive interpretation for which he contends. Moreover, this is, to my mind, a situation where the principle of legality is in play, as Lord Hoffman observed in the case of Sims. And the court can read that out. I know that the court will be very familiar with those important observations of Lord Hoffman in Sims, about
Yes.
the need for express provision or language that is only by way of necessary implication if one is going to interfere with fundamental rights. And it is in these circumstances we are required to interpret the statutory provisions strictly and restrictively. We respectfully submit that that same approach must be applied to these new bail provisions. It doesn't require, obviously you wouldn't only apply a strict approach if you had a case before you where there were stringent conditions. This is the general approach that one has to apply to the statutory interpretive task that the court is engaging. And it's the same one that the Supreme Court applied in B.
Is the first line of paragraph 30 of any relevance?
It's relevant in this sense, which is that the bail power previously, the person had to be detained.
Right.
So, but of course, they wouldn't necessarily. Mr. B had been detained, had been released for very many years, and had been on bail for a long period of time. Similarly, this gentleman obviously has been detained for about a year and a half, and then been on restrictions and subsequently bail for a long period of time. So he's in no different position to B.
Well, I understand those are the facts, but Lloyd Jones appears to be saying, and it seems to be in common ground, that as a matter of law, being detained was a condition precedent to the exercise of the power to grant bail conferred by the relevant paragraphs.
But that's not the reason why he adopted the approach, the strict and restrictive approach. That's confined within 27. That's a matter of.
Well, I understand.
Is correct as a matter of what the statute said.
I understand that's your submission, but it might be said that in Kadir, the House of Lords had determined that where someone was liable to be detained, certain legal consequences could follow.
Yes.
Including that they did not have to be in a situation where they could lawfully be detained. And now what we can see is that the power to grant bail has been conferred in a situation where a person is not, quote, detained, unquote, but is, quote, liable to be detained, unquote.
Well, yes, it does relate to that category of case, but it will also cover cases like this case where the person has been detained. So, as it was for Mr. B, he wasn't in detention at the time. He'd been on bail for about 5 or 7 years or something like that at the point at which this argument was taken in 2015. And it is because the statutory scheme itself allows for very severe curtailment of liberty, that the court adopted this approach.
I see.
And it had applied it to bail, and we respectfully submit that when one is construing these bail powers, the same approach should apply. You will see that applying that approach, the court concluded, it went on at 31, below G to H, that these provisions must be taken to refer to detention which is lawful. This conclusion is reinforced by the fact that in respect of each category to which it applies, paragraph 16 refers to detention under the authority of an immigration officer. This makes clear that the provision is not addressing the mere fact of detention. This must refer to lawful authorisation for detention, as the Court of Appeal concluded in the present case. It would be extraordinary if Parliament had intended to confer the power to grant bail where a person had been unlawfully detained or could not lawfully be detained. The words employed are certainly not appropriate to refer to a state of purported detention or to embrace both lawful and unlawful detention. I consider that detained in paragraphs 22 and 29 refers to lawfully authorised detention.
Yes.
And we say that you should read that approach into the new provisions, which I'll show you, when it refers to liable to be detained, because you have moved from a very limited form of restriction on liberty, which was temporary admission, a form of authorised status with limited conditions, to bail, which is it's more equivalent to an outlaw status. It doesn't give you any status in the country. It doesn't give you any authorization to enter, and it allows very strict conditions to be imposed. You will see that and this is important when we come to look at the statutory scheme in place, that supplementary arguments that were accepted by the Supreme Court include, as you see at paragraph 32, that the Secretary of State's construction had a number of practical consequences and difficulties. And if you look just above B, the power to grant bail can continue to be exercised after the person has ceased to be detained. However, this fails to address whether there needs to be a continuing power to detain as a precondition to the grant of bail. Here it seems to me that unless there is a continuing power to detain, the system of bail within Part 1 of Schedule 2 would encounter substantial difficulties in its operation. Ms Harrison, on behalf of B, draws attention to certain features attending the grant of bail. First, paragraph 22(1)(a) and paragraph 29(2) require the detained person to enter into a recognizance or appear before an immigration officer at a name, time and place. When he does so, it is then for the immigration officer to refix bail if he or she considers it appropriate to do so, and to determine whether any appropriate conditions. So that's the surrender power, which is a problem. And then secondly, it's difficult to see how this would operate if there was no continuing power of detention. So that's the circumstance where you've been put on bail by the First Tier Tribunal. One of the conditions, which was the conditions here, was that you appear before an immigration officer. So you're effectively surrendering your bail, and then the immigration officer is able to place you on now only bail. Then it included also restrictions, but that period of time, there's no provision for being effectively in detention at that point. We then go on to see that the second difficulty was that bail could be refixed, but until it is, the individual cannot simply be at liberty, neither detained nor granted temporary admission. Secondly, and more fundamentally, Ms Harrison points to the situation in which it becomes necessary to re-detain the person on bail, for example, because he or she is in breach of the conditions of bail. This would not be possible in the absence of a subsisting lawful power to detain. In the absence of such a power, conditions of bail and recognizance entered into would be unenforceable. 33 is also important. Perhaps given the time, could I just ask the court to read 33 and then I'll just make some submissions on it?
Yes.
So what we would like to particularly emphasise from paragraph 33 is the finding by the Supreme Court that the breach of bail itself and the power to arrest for potential or actual breach of bail is not the source of the power to detain. It has to come from the underlying pre-existing authority, which can only be from the provisions within the Immigration Act, and that will be important when we look at the current provisions.
Yes.
If we then go on, and again, I'll just ask the court to note that the learned friend's reliance on Qadir and seeking to read Qadir into this regime was rejected.
Yes.
The submission is at 35, and the detailed rejection of why that is between 37 and 39, we respectfully submit that the observations that were made as to why there's a distinction when one is construing a power, more limited power, such as temporary admission, as opposed to bail, apply here. Certainly 1. 2 is, of course, the words that we used, but then 3. In particular, 1 and 3.
Yeah, so is it of any significance that if we look at subparagraph 1, it says Kadir's case is a decision not on detention or on the power to grant bail
Yep.
under paragraphs 22 or 29. In other words, it's not simply saying or on the power to grant bail.
Well, there's nothing in the statutory language in 22 and 29 or 21 that make the difference. It is because temporary admission and bail are fundamentally different concepts. So it wouldn't be appropriate to read over Kadir to circumstances concerning bail.
Well, you say that, but in subparagraph 2, Lord Lloyd-Jones appears to be drawing attention to precisely that distinction of wording. The distinction between a person detained and a person liable to be detained is clear and must have been deliberate.
I accept that. There was, under the previous provision, a distinction between liable to detained and detained. But the distinction was linked to particular forms of restriction that could be imposed on somebody. So if you were liable to be detained, Parliament decided that it was appropriate to have very confined, limited conditions that you could impose on people, and you wouldn't be subject to detention if you breached them. Differently, bail, where it was predicated on having been detained, and then you've been released on bail, and where a huge potential array of different restrictions on liberty could be imposed. And in those circumstances, that was the underlying reason for Parliament's choice of those two words. Once you get to Schedule 10 and you no longer have any more this more confined, limited power, you only have bail, and with all the powers that are open to you, then that distinction is no longer a good one.
Yes.
Because that distinction is got to be based in substance, and the substance is all about the nature of the power that the state is exercising over the individual. And so that's why we say 1 and 3 read over to the current situation. And certainly, we won't take you to it now, but Lord Dyson in B in the Court of Appeal said if Kadir was said to apply to bail, then he was wrong. I think it's paragraph 33, because for all the reasons that are explained here, you couldn't have adopted the same interpretation of liable to be detained if it was being applied to bail, because of the very different nature of that category, of that particular form of restraint. Not least, ultimately, we respectfully submit, because it's predicated on lawful detention. That's what gives the state the power to impose very strict conditions. And that position, we said, and the Court of Appeal accepted, was reflected long-standing provisions of the common law. You'll see that at paragraph 47 on page 85.
Yes.
The Supreme Court didn't need to rely on the older authorities. You'll see that at 48, and in particular paragraph 49. And again, because it's important, could I ask you to read that paragraph, and in particular the reasoning of Lord Justice Stanley Burnton in the case of Stellato.
Yes.
These cases are all in the authorities' bundles,
Yes.
but I hope you caught, these are the key paragraphs that are there.
Right.
your lordships have read those paragraphs, I could just emphasise these 2 points about the Stellato judgment in its endorsement by the Supreme Court, is that what is recognised is that when one is concerned with bail, and this is a term of art which has centuries of existence in the common law, it is recognised that it is true conditional release. It is a qualified grant of liberty made by the grant of bail, such that if you breach it, you're liable to be returned to custody. That's the central notion of what bail is. And that is distinct from temporary admission. And what's secondly important is that the legal authority to detain doesn't come from the breach of the conditions. It comes from the underlying power to detain, which remains in place throughout. And there's a second and important way in which that is relevant, which is then set out in paragraph 50 and 51. Because the courts have recognised that principle. You'll see there the reference to the case of Conan, which is an early decision of Mr. Justice Collins, where he roundly rejected the proposition advanced by the Secretary of State, which was Mr. Kovacs, that in an unlawful detention case, the fact that bail had been refused was relevant to the question of the lawfulness of the detention. And as he makes clear, when one is considering bail, there's no power to determine the lawfulness of the detention. The grant of bail presupposes the power to detain, since a breach of a bail condition can lead to the reintroduction of the detention. And that authority was approved by the Supreme Court in the Lumber case.
Yes.
Where it's a paragraph. It's a paragraph 118.
Yeah. And just to be clear, Lumber is WL Congo.
Yes. Yes. And as I indicated to the court, that's the proposition that has been advanced by the United Kingdom to the European Court of Human Rights in Strasbourg, all of those cases being cited and referred to. And if I could just ask you to take up that case, it's in, I have it in volume 3.
Sorry, which case?
It's the case of Ismail, and it is sorry, I'm grateful to my learned friend. It's 69, so you may have it in volume 2.
It's tab 69.
Tab 69, if that's of assistance.
Right.
This was a case in which the appellant was the applicant was alleging that he had been denied a effective remedy for the lawfulness of his detention because of delays in provision of a bail hearing. And that was rejected by the Strasbourg court, essentially because bail is not a 5-4 remedy. But in addressing that, you'll see the facts are at paragraph 6 to 8, which I don't ask the court to look at now. But you'll see that, ironically as it was, Lord Lloyd Jones had refused permission to apply for judicial review because of the Conan decision, that bail wasn't a remedy for unlawful detention under the Strasbourg, under Article 5. And then you'll see that there is a recitation of the domestic law between 12 and 14, referring to the cases that are referred to by the Supreme Court in B. You'll see the government's argument at paragraph 16 on page 1897. and the conclusion of the court was that at paragraph 28,
Yes.
and paragraph 30 in particular. Bail, ultimately, you see on the penultimate lines, is not about the examination of the lawfulness of the detention, either under national law or in terms of the convention. And that approach reflects the long-standing position of the Strasbourg court, going back to an earlier case of Zamir, where the court had made a similar conclusion. So in it's at, I found it. It's at tab 63. And if I could ask the court to look at paragraph 109. Where the court recognised that when one is seeking an Article 5.4 remedy to challenge the legality of detention, it is independent from the possibility of applying to the court for release on bail. So the Strasbourg case law fully reflects what has been the long-standing position under the common law in respect of bail being predicated on the lawful power to detain. I, of course, accept that Parliament can, if the clearest possible words are used, expressly or by necessary implication, override those fundamental principles of the common law, but the approach to interpretation we respectfully submit is the one that was identified by the Supreme Court in B, and it is strict and narrowly construed. Principles of legality are at play here, and it would also be a position where you would be concluding that fundamental principles of the common law are overridden, and it would have implications for habeas corpus, because as we've seen in the B decision, bail is not an adequate remedy if what you're seeking is a writ of habeas corpus. You will still be entitled to that writ to release, even if you've been admitted in the interim to bail. It means that we are here in the category of situation where the court's approach has to be the most stringent of approaches to the statutory language that has been used. And we say, therefore, the requirements that the Supreme Court in B identified at paragraph 53, the clearest possible words would be required to achieve a contrary result. And obviously Parliament did not do so in that case. This case then is whether the clearest possible words have been used, and whether or not the reliance that the learned judge below put on the legislative history is that which can only ever be a starting point, and can be, in any event, has to be subject to the language that was actually used. Is that going to be a sufficient alternative basis for rejecting the submissions that we make? And we say that the learned judge was wrong to do that. So what I'm going to, I'll come back to some of the elements of statutory interpretation, but because I want to take you to the actual provisions now, we may have to come back to it. Yes. It is a primary ground that we assert that the learned judge approach to interpretation, which was the basis on which she granted permission, she recognised there could be a different approach to interpretation, if you adopt the approach that we submit, is the correct one in light of all the ways in which you here have a provision that infringes liberty, overturns long-standing common law principles, interferes with the remedies for habeas corpus, and of course, if we're right, engages Article 5 and 5.4, those interpretive obligations would lead you to adopt the approach we submit, which is to read into liable to be detained, lawfully detained. Lawfully not just meaning, is there a power in existence, which is the Secretary of State's case, but in an alisminic sense, can't be lawfully exercised. So then if we can go to the statutory provisions now in play, which are in tab 3. And we'll see Schedule 10 coming into force on the 15th of January, and thereby repealing paragraph 61. That is in tab 2. So if we just look at that first.
Yes.
So implemented following the Court of Appeal judgment in B. And the key paragraph is 3. A person may be released and remain on bail under paragraph 22 or 29 of Schedule 2 to the Immigration Act 71, even if the person can no longer be detained under a provision of the Immigration Acts to which that paragraph applies, if the person is liable to detention under such a provision. And 5 was the retrospective effect. I've already indicated what our submission is about the way in which this is to be interpreted. Can no longer be detained is referring to those where detention is no longer justified. That's the largest category of case where detention would not be necessary, as opposed to whether it would be lawful. And we submit that applying the strict interpretation that's mandated by the Supreme Court in B, liable to detention means the wider category of lawful detention that would embrace detention in breach of the Hardale-Singh principles. That provision was repealed on the coming into effect of Schedule 10.
Just before we leave that.
Yes, sorry.
I'm sorry, I'm being a bit slow. Who do you say, what category of persons are described by Section 61(3)? That is, a person who can no longer be detained, but is liable to detention. Who fits into that category?
It fits into the category of the vast majority of those subject to immigration control, where either there is they can be lawfully detained, or they.
In what sense, if someone can be lawfully detained?
Yes.
I mean, as I've understood it, you say the vast majority of people who are of the 90,000, the vast majority of them are people who have never actually been detained.
Yep.
Because it's not necessary.
Yes.
But in what sense? They can still lawfully be detained. They don't fall foul of the Hardale-Singh principles.
Correct.
But in what sense do you say they can no longer be detained?
Well, they can't be on the simple use of the words. They can no longer be detained. They can't be detained. They can't be detained because it's not justified to do so.
I mean, because bail is more appropriate.
Well, bail is the only option at that point. So that's why you need to be able to put all that. You've got to transfer a whole category of person. Potentially, it must have been thousands of people who went from temporary admission or restrictions into bail. So it was making it clear that they could be put on bail in circumstances where that power wouldn't have been in play, wasn't in play, and couldn't have been in play previously. So you had to deal with this transitional position.
So, but Section 61(3) was not dealing with the transitional period, it was dealing with the past period.
Well, yes, it was, and it was
and
dealing.
up
It
to
was
the point
making
where
what
the-
was currently happened. It was intending to make that lawful. That's correct. Yes, it was. But it was all. It was having to deal with that. Sorry, it was having to deal with that category of case, who could have made an argument that, well, I'm not. There's no power to lawfully detain me. You've never detained me. There's no reason to do so. I've complied. I'm not an abscond risk. I'm not a foreign offender. What are you going to do with me? They weren't going to be able to use the argument that had succeeded in B. And in addition,
I'm sorry to stop you, but as I understand it, your submission is that the person is liable to detention if they can lawfully be detained,
yes,
even though there's no justification in their particular. It's not necessary to do so.
yes, that we have to
You
deal
have to
with.
distinguish between
Yeah.
someone who cannot lawfully be detained. You say they're outside this paragraph entirely. Someone who can lawfully be detained, but it wouldn't be justified to do so.
Yes,
And you say that's the category of persons to which this applies.
yes,
So when it says at the end, if the person is liable to detention, it means if that detaining them wouldn't breach the Hardy-Singh principles.
yes, yes.
But in
It
what
would.
sense then can it properly be said of such a person that they can no longer be detained? That looks like somebody who could have been detained at an earlier stage, but because of a lapse of time, can no longer be detained.
Well, those categories of person where it's not justified to detain them could have been detained in principle. They could have been. The power was there, but it wasn't exercised because it wasn't necessary. And that's obviously distinct from those where there's no lawful power to detain, the very small category of person that fall within that group. Ultimately, this language is unclear. That's the best that one can say. If Parliament wanted to make it crystal clear, which is the standard that has to be met, the clearest possible words, it needed to say can no longer be lawfully detained. Why not? Why didn't Parliament simply say that? Because and the absence of that express provision, we respectfully submit, renders this provision incapable of doing what the Secretary of State says it should do. Strictly and narrowly construing those very broad, wide words that are ambiguous, that are not easy to completely understand, it has to be a point in my favour, because this is a circumstance in which we need express the clearest possible words to allow for the possibility of putting somebody on bail and therefore making their liberty conditional on compliance, which it wasn't before. That's what's necessary here.
Ms. Harrison, in subsection 3, the last clause
Yes.
provides if the person is liable to detention
Yes.
under such a provision. So,
Yes.
if I understood this correctly, your submission is that there, again, Parliament means if the person is liable to lawful detention.
Yes, in the wider sense than the one advanced by Mr. Tam.
And therefore, the court is required to give a different interpretation to the phrase liable to detention in this provision from the one given by the House of Lords in Kaitey.
Yes, yes, because unlike Kadir, which was only concerned with temporary admission,
Yes.
you've now extended it to a much wider category of person,
Understood.
including those who can't lawfully be detained.
Yeah, understood. And I may have misunderstood a submission you made earlier this morning, in which case, please do correct me. But do you or do you not accept that Parliament enacted this provision to reverse the effect of the Court of Appeal decision in B, Algeria? Because one notes that this is in time before the Supreme Court.
Yes, it is. That's what Mr. Tam says, and the
Yes.
explanatory notes say it is to put the position back to what the settled law was before.
Yes.
So that is wrong. So whatever Parliament had in mind,
Yes.
the settled law,
Yeah.
as we now know from B, was that bail is predicated on lawful detention. And so insofar as we can glean anything from that history and what's said in the explanatory notes is misleading.
Never mind what the explanatory notes say.
Yes.
I just want to be clear what your submission is. Do you or do you not accept that this was Parliament reversing Court of Appeal in B?
I don't accept that it was necessarily, no, I don't accept that it reversed the position in B. Instead, what it did was to limit the scope of the impact of B, because B was only concerned with the narrow category of case where you couldn't be lawfully detained consistently with the Hardale-Singh principles. But the full implications of that judgment were potentially very much wider. And so it was to address that situation. And obviously, to that extent, it has, I appreciate it fits in the history, but in terms of our task of looking at the language that is in place and relevant, we have to then look at Schedule 10 because it's been repealed. And then where the words are used again, which is Schedule 10.1.5, it has to be in the context of what I'd said to my lord, and my lord was right to correct me about Section 61.3, but it is in that, making that transition period.
Yes.
So 61.3 is to avoid wide repercussions and potential claims for damages and whatever else as a result of the implications of the judgment of the Court of Appeal in B, which obviously were never had to be worked out. There were some subsequent cases. But now we get to Schedule 10 and we look at what Parliament actually intended to do, what it meant to do, when it had this scheme ready to put into place to substitute the provisions that I've showed you already in the 1971 Act. So we see in Schedule 10.1 the circumstances in which the Secretary of State may grant bail, and A to D all include where the person is being detained, and 2 adds is grant a person bail if the person is liable to detention under a provision mentioned in subsection 1. So it changes the previous bail provisions, which were predicated on the person being in detention.
Quite.
But what it does do is to say, now that you can, and there obviously was a large category of person who were not in detention, but now needed to go on to bail because temporary admission and restrictions is gone. So that's dealing with them, and it says is liable to detention under a provision mentioned in subparagraph 1. Yes. We respectfully submit that obviously A to D, you had to be lawfully detained, and you therefore were liable to lawful detention under 1. You can't read into A to D being unlawfully detained. You have to proceed on the basis that they were detained lawfully, therefore you can grant bail, because that's the way that bail operates, and being liable to detention is liable to lawful detention under A to D. You see that there's provision in 10.1.3 for the First Tier Tribunal, similarly to grant bail, again, if the person is detained. And 4 is very difficult to properly understand, but you'll see it's not clear if there's also power to grant bail where the person is liable to be detained under 4. It's possible you can imply it in there by reference to what's said in relation to paragraphs 1 to 3 above. But what it does also do, and if it does, then it has to be construed in the same way that we've said, but what it also does is make it absolutely clear that when the FTT grants bail, it has a power to detain or to re-detain under paragraphs 10.2 or 13. So it's integral to the power of the FTT to detain the person if they breach detention, if they breach their bail conditions. 10.1.5 is the provision that uses the language from section 61.3, and that phrase, even if the person can no longer be detained, if the person is liable to detention, or the Secretary of State is considering whether to make a deportation order. And I've made my submissions about this provision, and I do respectfully submit that it does address clearly that big category of case of persons who were not detained and had been on temporary admission, and they are the category of person who could no longer be detained. And I make the point again that if Parliament wished to expressly and clearly overturn the judgment in B, it could have easily have said no longer be lawfully detained. Yes. That's all they needed to do, but they didn't.
Yes.
We then go on to the fact that 6 also makes it clear that a grant of immigration bail to a person doesn't prevent the person's subsequent detention under provisions in paragraph 1. And again, it has to be limited to lawful detention if they're going to make sense of this provision. Lawful in the full sense of the word, not just the Kadir sense of the word. And you'll see when bail comes to an end, which we've already seen in the individual case, and that it is that it only gives those options. It says if the person, in a case where paragraph 5 applied to the person, that subparagraph no longer applies to the person, i.e. they could be detained, it's justified to do so. The person is granted leave, or they're detained, or they're removed. It doesn't provide in the statute for some kind of limbo situation where you're at large. And that, it could be said by Mr. Tam, it's an implication of A, but again, that would be a dramatic innovation by Parliament to by default to say, well, if you can't fit in any of these categories, you have to be just simply at large. Then it's important to look at the conditions of immigration bail, and you'll see, and it's important in this context to bear in mind that the learned judge below said this was a new form of bail. It wasn't the classic bail, and we say that's wrong. When one looks at these conditions, I've already showed you how bail is it's conditional, it's contingent, and you can be re-detained, already integrated into the first sections in paragraph 1. Then if we look at paragraph 2, we'll see that the first condition is the requirement to appear before, the condition of requiring the person to appear before the Secretary of State or the First Tier Tribunal at a specified time and place, and that's surrender. And that's the form of language that in the case of AR Pakistan, which was referred to in B, Lord Justice Longmore described that as the classic element of a detention, of a bail power, that you are required to surrender to appear before. Obviously, the remaining conditions are all what one would expect, in the sense that they relate not just to restrictions on things like work and occupational studies and residence, which is what temporary admission used to cover, but have within them additional factors such as electronic monitoring and other conditions.
Yes.
A very broad depth. So no longer the exhaustive limited list, but a wide range of conditions that would be tailored, obviously, to whatever risk factors were in play. 2 is important because you'll see that it makes those provisions apply to a person who is being detained or is liable to detention under the provision. We say that would be interpreted consistently with being lawfully detained, to be able to impose those wider category of conditions on people. And 3 reflects the ruling of the Supreme Court in B in the case of Stellato, which are the paragraphs indented, because it makes quite clear that sorry, if I sorry, I've got the wrong paragraph there. 3 is the power to impose monitoring. 4 is financial conditions, which is the surety type condition, and the electronic monitoring would only be imposed if it's practical to do so, not contrary to the convention to the person's convention rights. But it's 11, sorry, that I had in mind. So if you see 2.11 in this schedule, bail condition in relation to a person on immigration bail means a condition to which the person's bail is subject. So it's that provision that reflects the approach of the Supreme Court in B and Stellato, that bail is a true conditional grant of liberty, which means that it comes to an end if there's a breach.
The reference to convention rights expressly in subparagraph 7b, is that of any importance? That suggests that Parliament, well, first of all, had in mind the convention rights, but secondly, that it wasn't trying to do anything to violate convention rights, rather it's trying to conform to convention rights.
Well, insofar as it relates to the imposition of a particular condition, which is electronic monitoring. So it had always been the Secretary of State's policy not to impose electronic monitoring on persons with mental illness, for example.
I see.
So it's about the conditions as opposed to the impact of the conditions as opposed to respecting the distinction that's made in Article 5(4) in particular about bail not being an adequate remedy. So I think it does address what might be the impact of a particular condition, which is electronic monitoring, but it doesn't go any further than that. Of course, the Human Rights Act will always intervene, but in this context, we say its intervention is through Section 3 to achieve a situation where bail is limited, at the very least, to the category of person where they can be lawfully detained.
Can I just take you back, Ms. Harrison, forgive me, to the critical provision, it might be thought, which is subparagraph 5 on the previous page. A person may be granted and remain on immigration bail even if the person can no longer be detained, if the person is liable to detention.
Yes.
Why doesn't that apply to the classic Hardy Singh situation? In other words, that someone is liable to detention, but they are no longer they can no longer be detained because there isn't a reasonable prospect within a reasonable time of deporting them.
Is your Lordship dealing with 5(1)(f)? Sorry, if I...
No, I'm on page 10.
Yes.
And towards the top of that page, the critical provision is subparagraph 5. That's the provision we're being asked to construe.
Paragraph 1.5.
Paragraph 1.5.
Yes, yes.
Yes, subparagraph 5 of paragraph 1. So let me just read it again. A person may remain on immigration bail even if the person can no longer be detained, if the person is liable to detention. So the condition precedent is the person is liable to detention.
Yes.
Right? And then why doesn't that apply to the classic Hardy Singh situation? By which I mean that a person is indeed liable to detention, as per Kadir.
Yes.
But to exercise the power of detention on their particular facts would be unlawful because, for example, they can't be deported within a reasonable time. And therefore, the words, the person can no longer be detained, why aren't they apt to describe classically that situation?
Well, in my respectful submission, because we are going to strictly and narrowly construe this provision in the same way in which it was strictly and narrowly construed in B, and so that there isn't a power in the statute to detain those who, to impose bail on those who can't be lawfully detained.
I see.
So it becomes So that's my answer to that. But I've given you the explanation as to how it can apply to a different category of case. It makes sense to other categories of case. But the question for the court is not just is it possible to interpret it that way? Strictly and narrowly construing it consistently with those principles, what's the answer? And has Parliament so clearly and expressly provided for that the only answer can be, at least at in terms of the domestic provisions, the statutory provision, that it's provided for imposition of bail, even though one cannot be lawfully detained.
Yes.
If I can just try and see if I can make a little bit more progress. If we go on to, I've showed you 211, which is about, as it was previously, bail is contingent and is contingent release. And then if we go over to 10.3, we look at the exercise of the power to grant immigration bail, and this provision makes it clear that the factors that are relevant to the consideration by the First Tier Tribunal do not engage with lawfulness. So just as previously the FTT had no power, it wasn't within its jurisdiction to determine legality, that has been preserved. So bail will not be a determination of legality of detention. It's paragraph 10.4 that provides for, at least in principle, for the purpose of this case, the provision to impose a curfew. So you'll see that at 4. So when you impose electronic monitoring, then you can require the person to cooperate with such arrangements for detecting and recording by electronic means one or more of the following. And it includes the location at specified periods of time, during that period, the absence from that location. So it's this provision that is utilised to effectively, as it were, reverse JALA and allow for individuals to be subject to a curfew when they couldn't have been under the previous provisions, because it would have constituted an imprisonment. So that's paragraph 13. And then 9, we get to the power to provide for accommodation, which was previously in another part of the section. But then we get to key provisions relating to arrest for the breach of immigration bail. Yes. And does it make sense for me to make my submissions on this now because it's important, or should we come back?
Well,
this would conclude the submissions on the statute. So would the court indulge me in making those submissions now?
Yes, if you're only going to be a few more minutes.
Probably 5 minutes maximum.
Yes,
it is important.
Yes,
At least I can flesh it out, and if I have to come back.
Yep.
But you'll see that this provision is the equivalent provision of what I showed you under the previous legislation in paragraph 24 of Schedule 2. Yes. So an immigration officer or a constable may arrest without warrant a person on immigration bail if the immigration officer or constable has reasonable grounds for believing that the person is likely to fail to comply with the bail condition, or has reasonable grounds for suspecting the person is failing or has failed to comply with the condition. So a power of arrest in 10.1. And then you'll see in 9 that a person arrested under this paragraph must, as soon as is practicable after the person's arrest, be brought before the relevant authority and may be detained under the authority of the Secretary of State in the meantime. So that's an important provision, because this statute provides for the person who's been arrested for possible or actual breach of bail to be detained under the authority of the Secretary of State. And this is in fact different wording than we found in Schedule 20, in paragraph 2, Schedule 24. But authority of the Secretary of State can only mean lawful authority and can only mean the powers to detain under Schedule 2 or Schedule 3 of the 1971 Act. The authority of the Secretary of State, as I showed you in B, paragraph 33, was an important part of, was an aspect of why it was that it had to be lawful. Those words have been used here by Parliament under the authority of the Secretary of State, recognising, we respectfully submit, that if you're going to have a power to impose bail and consequences for breach of bail, there has to be an underlying lawful authorisation for detention. And so that's critically important in terms of, is this a classic bail power or something new? It's a classic bail power. And it is one that has to be predicated, just as that long line of authority that led to the judgment of the Supreme Court in B, on lawful detention. And not just that there is a power in existence, but that it must be able to be lawfully exercised. So you'll see then that the relevant authority is the Secretary of State, if the Secretary of State granted bail to the arrested person, or the First Tier Tribunal. Otherwise, the First Tier Tribunal.
Can I just be sure that I've understood your previous submission? Your submission is that subparagraph 10.9b on page 18
Yes.
is not a provision which confers power on the Secretary of State to detain somebody who's been arrested, but is a cross-reference to the Secretary of State having some other authority under the Immigration Acts to detain.
Yes, so that's exactly. So that there is a power to arrest in 10.1 if you've breached or you might breach bail, but in being able to hold you until you come before a court, which used to be 24 hours and is now no limit on it in comparison to 24, that has to be under the authority of the Secretary of State, if the Secretary of State is the person who's granted you bail, which is going to be the vast majority of cases. That authority must be lawful authority.
That wasn't quite my question. My question was,
Sorry.
This in itself doesn't confer power on the Secretary of State
Yes.
to detain.
Yes.
This is a cross-reference to a Secretary of State exercising some other lawful authority that the Secretary of State has. That's your submission.
That is correct, yes. And
Thank you.
that is the submission that was accepted in B and the finding of the court, that the breach of bail itself and those powers don't confer the authority.
Well, I mean, you say that was a submission accepted in B. B wasn't obviously construction of this paragraph.
Of course.
What the paragraph says is a person may be detained under the authority of the Secretary of State. And the question is does that mean may, by virtue of this paragraph, be detained if the Secretary of State so authorises it, or does it mean the Secretary of State could use other powers elsewhere to detain? That's
yes.
the question.
And I agree that it's other powers other than what's contained in this provision,
Yes.
and those other powers are Schedule 2 or Schedule 3 of the Immigration Act, and it must be lawful. And then we go on to see what the authority, the relevant authority must decide whether the arrested person is broken or is likely to breach any of the bail conditions, and then in those circumstances at 12, if the relevant authority decides the arrested person is broken or is likely to break any of the bail conditions, the relevant authority must direct that the person is to be detained under the provision mentioned in paragraph 1.1, under which the person is liable to be detained, or grant the person bail. So I agree that there is an option to release, but on bail, but the statute itself also provides for circumstances in which there is a power to detain for breach of bail if the person is liable to be detained. So on the Secretary of State's construction, that must mean somebody who can't be lawfully detained consistently with the Hardale-Singh principles.
Sorry, you introduced the phrase, if the person is liable to be detained. I don't find that there.
direct the person is to be detained under the provision mentioned in paragraph 1.1, under which the person is liable to be detained.
Exactly. It says under which, not if the person is liable to be detained.
Under which, yes. So it can only be if you can be lawfully detained.
Yeah.
And that's lawful in its wider sense.
Yeah.
It can't be, because on Mr. Tam's case, liable to detained in the Kadir sense, it limited only to where there's no power in existence. And that's why Mr. Goodman below emphasised this provision, because it clearly cannot be, on its face, cannot be construed compatibly with legality, principle of legality, or protecting liberty if he's correct. And we do respectfully submit that it is not sufficient simply to say, well, the judge wouldn't detain you, but would put you on bail if it is a judge or the Secretary of State. You have to construe this statute as a whole. We've seen how being able to be re-detained for breach of bail is integral to it, as you would expect in a bail provision, contrast temporary admission. And it is therefore predicated and must be construed to be predicated on lawful detention in the broader sense, covering Hardeel Singh.
Right. So does that cover the
I
legislation?
think that covers, there may be just maybe one or two other little points, but
Can I
that's
very-
the main
Can I
submission.
very briefly draw attention to paragraph 13 before we break,
Yes.
which deals with
Yes.
transitional provision. And maybe the answer to the issue we were discussing earlier about how you can translate restrictions under a restriction order previously existing into bail conditions under the new regime. And it seems on the face of it to empower the making of regulations for that purpose. But I don't want to take time up on it now, but before we left the schedule, I thought I should mention it.
Yes, thank you.
I'll I'm grateful for the court referring that to me, and I'll come back and deal with that shortly after the short.
Thank you.
short
Now, how are you doing for time? How much longer will you be this afternoon?
on the timetable, I've got another 45 minutes.
Right.
So I hope I'll have to. I think that should be okay.
All right.
That was it would be Miss Dubinsky and I think then Mr. Tam
Yes.
shortly this
Yes.
afternoon.
Well, I'm grateful to all counsel for having agreed a timetable, and we must stick to it. So, given the time, I think we'll now resume at 2:10.
Right.
I don't know the answer. I don't know if you do know the answer of what happened in that when it came into force. What was the
Transition plans, everything automatically became immigration back.
automatically? Okay.
Yeah, because the regulator would trace them through the